Hello, everyone, and welcome to our annual survey discussion about ethics for lawyers. Before we begin, a couple of housekeeping announcements, or one, in fact. You will receive your MCLE credits shortly after the program. Please take a moment to complete the survey that is included with your certificate. Okay, so I'm Neville Johnson. I'm a partner at Johnson Johnson in Beverly Hills. We do serious litigation, entertainment, business, class actions, and we do sometimes prosecute legal malpractice and defend the same. Our other guests are Ellen Pansky, Pansky Markle, who is just one of the top state bar defense lawyers in California. David Simani is a partner at Lewis Brisbois, and he specializes in legal malpractice and malpractice in other professions as well. And we're very happy to have him. We got a lot to cover. Ms. Pansky is going to take the first half hour or so. And after that, Mr. Simani will be talking about legal mal. I'm going to spend a few moments now on just some points that I think are important and you should keep in mind. And also, if you have questions, send them to chat and we'll try and get to them if we can. Number one, if you didn't learn this in law school, you should have learned it in law school. Clients are not your friends. As soon as the money comes in, any lawyer could have done that, and you know that because it's happened in your experience. So be careful. Get it in writing. When there's a continuing interest that you're entitled to, royalties, record royalties, movie royalties, whatever it may be, if you don't have it in writing, you're out of luck. And we know that from the Johnny Depp case, which I have provided as part of the materials, the Jackaway Tireman case 10 years ago, where there was a trial and they lost because they didn't have written fee agreements. Finally, next is conflicts between the client. When you are signing a client who has an LLC, you must get a conflict waiver, or it can come back and bite you. And we're going to hear about the Shepard Mullen case later on, which I have provided. You should probably read that because that's a very sad case for lawyers and their fees overall. Document everything. Have attorney fee clauses. If you be careful of those if you're going to have them in fee agreement, and document them if the client can get bitten by an attorney's fees clause in a contract or a fee shifting statute. In copyright, for example, you got to tell the client, you lose, you may have to pay the other side. And if it's Civil Code 3344, which is the right of publicity statute, it's mandatory. The winner prevails. So put that down, put all risks down all the time. Never be the third lawyer on a case. If the reason that is being said is because the other two obviously had serious problems with the client. Don't take the client to the case if the client does not present well or gives you the creeps. Have good insurance and get tail insurance if you're nearing the end of your ride as a lawyer. As to the state bar, clients will threaten you sometimes to reduce or waive a bill. Expect this. This is if it hasn't happened to you, it's going to happen to you. And sometimes they'll pay the bill, and just to spite you, they will make a claim against the state bar. Keep good time records, even if it's a contingency case. Finally, we recommend, I'm not a fan of arbitration clauses in contracts, generally speaking, and I prefer the court system. It's faster and much less expensive. When it comes to attorney fee agreements, we recommend that you have an arbitration clause to keep your business off the street. But something we've seen lately is the client coming back and saying, hey, wait a minute, I can't afford this now. You got to pay it, Mr. Lawyer, if you're going to try and prosecute an arbitration for a fee dispute or malpractice or whatever it may be. With that, Ms. Pansky, please take it away.
Thank you, Neville. Thank you. It's a pleasure being here again this year. And good afternoon, everybody. I want to reinforce a couple of the things that Neville just mentioned. Apropos of his comment about the client is not your friend, a lot of lawyers think that the state bar is a trade association, that the state bar is there to help lawyers. State bar is not your friend. So take it seriously if the client is threatening you with a state bar complaint, or opposing counsel tells you they think you have a conflict and they're going to move to disqualify you, or they file a state bar complaint. Don't assume that the state bar is there, to assist you or to give you the benefit of the doubt. And that's another reason why, as Neville mentioned, it's important to document your file, particularly when the client has a decision to make. One of my pet peeves now is practicing law via text, or heaven forbid, via tweet. It's much harder to preserve a record of those communications. In my view, you never want to get a client's consent either to settle or for a particular essential term of a contract by a text message or phone call, for that matter. If you do have verbal communications, make sure that you record it, have a confirmation in writing of one form or another. If it's not in writing and the client says it didn't happen, the state bar will assume that it did not happen. Let's jump right in. I want to start by talking about the theme that I have today is mostly money issues. And as Neville indicated in the two cases that he's provided you in the materials, the order from the Johnny Depp versus Bloom case, and also the Shepard Mullen versus JM Manufacturing case. Both of those are cautionary tales for lawyers. I want to talk about them, and actually I want to get David's input as well. And
let me stop for 1 second and say that the materials are available, and if you go to the chat room, you'll get the way to connect with them. Back to you.
And also I have some materials with some of the applicable rules of professional conduct excerpted for you. So again, very easy for you to access that link. So let's talk about the fee agreement. In addition to what Neville's already said, one of the reasons that I feel very strongly that you should have a fee agreement every time for every new engagement, typically, even if you have a longstanding client who you represented for many years in various things, is that when you do the fee agreement, you have an opportunity to establish the scope of the engagement. And when you are preparing your fee agreement, please do not include some general description like represent the client in all their business affairs, because then you've got an open-ended contract. The client can come back later and say you either failed to perform because this was within that general scope of representation, you did not represent me, or the client will say you need to do all this extra work for the same fee because that's what you agreed to do in the fee contract, when really you knew and the client should have known at the beginning that the type of services or the completion of a certain task was all that compensation was intended to cover. So for that reason alone, you should have a fee agreement. But the other important reason why you should have a fee agreement is that, as the lawyers learned in a very hard lesson in the Johnny Depp case, under the statutory scheme, if a lawyer does not have a fee agreement, unless you fall within one of the very narrow exceptions, then the lawyer cannot enforce the fee agreement, period. If it's not in writing under the Business and Professions Code, the lawyer is limited to quantum merit. Quantum merit means the reasonable value of the services. And that's where Johnny Depp ended up prevailing, because under the statute, it's Business and Professions Code section 6147 if it's a contingent fee, and it's 6148 if it's an hourly fee, or I should say a non-contingent fee. For example, you could have a flat rate fee. I want to digress for a second and tell you that in case you don't know this, we in California are governed by two separate, distinct sets of rules. One set of regulations is the California Rules of Professional Conduct. Those are rules which are presented by the State Bar to the Supreme Court and adopted by the Supreme Court of California. But in addition to that, we are also regulated by the legislature as part of the State Bar Act, which is Business and Professions Code section 6000 et sec. And they both apply equally. There is no disciplinary rule in the rules of professional conduct that governs written fee agreements. So my argument, whenever there's a State Bar complaint to the effect that the lawyer did not have a written agreement, is it's not a disciplinary offense. It's not in the rules of professional conduct. However, it has been deemed by the State Bar Court of California to be an aggravating circumstance in some cases. So if there's overreaching, if there's a question about whether the lawyer has fallen somehow into an ethical breach in their services or the way they charged their fees or collected their fees, the fact that there was no fee agreement could end up being an aggravating factor. So in the B&P code section, again, 6147, 6148, the case law has developed that if you have not complied with each of the mandatory provisions called for in the statute, then the contract may be unenforceable. The important point to remember is that fee agreements, if they are non-compliant with the B&P code, are voidable at the client's option. They're not void, but they're voidable if the client chooses to void them. So that's pretty much the foundation of the Johnny Depp case. And in that case, because the lawyers did not have a written fee agreement, when they went to the determination of what their services were worth, they received far, far less than what they would have received under the contract. So go back now and make sure that when you're representing your clients, if you neglected to get a fee agreement, although there's no case law on this, that just as there's no case law which says if you neglected to get a conflict waiver that you can cure it retroactively, in my view, it's better to have a writing than not to have a writing, even if you get it belatedly. And obviously you're not going to backdate it. You're not going to conceal that you didn't get it at an earlier stage. Be transparent about it. But as we get into the conflict area, I think you'll see that it is crucially important not to neglect to have a sufficient disclosure of conflicts and have a written waiver. You need to have it signed by the client. In some other states, the rule is that the conflict waiver has to be confirmed in writing, meaning that it's sufficient for the lawyer to send a letter or an email confirming that they've discussed this with the client and the client has consented and has agreed to waive the conflict. California, that's not the case. The client has to sign it. So let's talk about the way fees are sometimes charged. And Neville, maybe you can jump in here. When I've represented entertainment lawyers or have been involved as an expert witness in fee disputes between the client and entertainment lawyers, one of the issues that frequently arises is that, from what I gather, it's pretty standard that if a lawyer is representing talent, they're going to get a percentage fee that attaches to the product, to the project, to the intellectual property, whatever that product is. The lawyer sets up the fee agreement, so they're going to get paid essentially forever when that product continues to generate royalties. Is that basically correct, would you say, Neville?
Yes, absolutely. And the question is, in relation to that, do you need a conflict waiver when you're taking a percentage? And advise them to get independent counsel? Generally
not. So generally, and the cases support the proposition that a fee agreement is not a business transaction between the lawyer and the client. Let me just give you a brief little primer on that. So the conflict rules have always been separate from the financial interest of a lawyer in the client property issue. And in that respect, sorry, just let me turn this off. It's important to realize that even though I usually recommend it, and I'm sure David does also, there are times when if you're getting a conflict waiver, you should say absolutely in writing to the client, you have the right to independent legal counsel before you decide to waive this conflict. And by signing this, you're acknowledging that you know that and that you've had a sufficient opportunity to obtain such independent advice if you choose to do so. That's not required for a conflict waiver. It is required when there's a business transaction or the lawyer receives some sort of ownership or security interest in the client's property. If the lawyer is getting any kind of pecuniary interest in the client's property, that additional admonition has to be given in writing, and the client has to consent in writing and confirm that they've been told they have the right to independent legal counsel. But the case law generally is that the fee agreement is not a business transaction with the client. The exception to that is where, for example, the lawyer says, okay, I want security. I want you to give me a promissory note secured by the deed on your house, or you're going to give me shares of stock. You're going to give me some property to secure my fee. In that case, I always recommend that you do treat it like the business transaction and do that extra step, because you need to do that to protect yourself. So the answer to that is yes and no. If it's a straight contingent fee, there's a California State Bar formal ethics opinion which says you don't have to comply with what used to be Rule 3300. Under the new rules, it's Rule 1.8.1. But on the other hand, the Supreme Court has said in a case called Fletcher versus Davis that if you have an hourly fee agreement and it's secured by the client's ultimate recovery, that is a business transaction, and you do need to have the separate disclosure and waiver. So if you have a question in your mind, go ahead and do it. It's a one more paragraph that you throw into your retainer agreement, and there's no reason not to do it. The other issue, though, I've seen on this scenario is what happens when, after the lawyer begins to represent the client and they ink the deal, the project's gotten picked up, the client's getting royalties, and now a dispute or a disagreement or an irrevocable breakdown occurs in the attorney-client relationship and the lawyer is fired. Can the lawyer continue to enforce that fee agreement and collect going forward, even if some other lawyer has now been hired to continue to do the work? The lawyer has nothing to do with the future royalties that may be paid on that, whatever that intellectual property is. Is that an enforceable agreement? I've seen it go both ways. I've seen, and often that situation results in the client making a state bar complaint. So you're not only talking about a fee dispute that you may resolve either during fee arbitration or, you get sued and it'll end up in the state court, but it can also separately end up, and in addition to the civil dispute, can end up at the state bar. Typically, the state bar is not going to get involved in fee disputes. It's not going to be the arbiter of whether a contract is enforceable or not when you're talking just about fees and there's no other ethics issue involved. But keep in mind that there's the overarching question whether a fee is unconscionable. In some other states, the disciplinary rule uses the standard of unreasonable. In California, it always has been and remains, the standard is unconscionability. What does that mean? It means it is so exorbitant that it shocks the conscience. It is so far outside of the fee that lawyers practicing in this area of law, in this community, would charge, that it's unenforceable because it's so unreasonable, so unfair to the client. There could be an argument that if the lawyer was fired and the lawyer's not continuing to do any work, it's basically just a windfall to the lawyer for doing nothing for, basically, to infinity. That could be seen as an unconscionable fee. So in those kinds of situations, when a lawyer finds himself in that kind of dispute with a client, my advice is to try to resolve it. It's better, it's the old cliche, a bird in the hand is better than two in the bush. I'd rather, see the lawyer, work it out with the client, get paid something than end up, heaven forbid, in a lawsuit, a state bar investigation, or maybe even finding themselves getting a public disciplinary record, which, by the way, let me just say, if a lawyer is disciplined by the state bar at anything but the absolute lowest level, it goes on the state bar's website on the membership profile page, and it never comes off. There is no expungement procedure at all. So the last thing you want to do is to receive state bar discipline and have it follow you for the rest of your career. Another big area that I think bears mention is the area of referral fees. So under the old rules, and again, if I didn't mention it, in California, we got an entirely new set of rules of professional conduct that were effective on November 1, 2018. California was the last outlier to adopt some version of the ABA model rules. And by the way, for those of you who had to take the multi-state ethics exam to become a member of the bar, which is probably most of us now, I think that obligation started in the early 70s. We didn't learn the California rules. We learned the ABA model rules. Well, California now has a version of the ABA model rules, which in some respect just means that we've adopted the ABA numbering system. Our rules are unique. Many of our rules are very different from the ABA model rules. So if you haven't read them, please do so. Or when you're taking a general ethics MCLE overview at the end of your compliance period, find one that will walk you through the rules, because there are some major differences. And one of those, for example, is that there's been a major change to the referral fee rule. Under the old rule, in order to enforce a referral fee, there had to be a writing, but not until the division of fees occurred. So the lawyers could wait till the end of the case, when there was some money to be divided, and then they could enter into an agreement and get the client's consent. Keep in mind that even under the old rule, it's not enough to just say to the client, okay, Neville Johnson and I are going to work together on this case, or he's referred me the case and I'm going to give him part of my fee as a referral fee. Do you consent? Even under the old rule, you had to tell the client, these are the terms. So you have to tell them exactly what percentage or what amount is being paid from the one lawyer to the other lawyer. Otherwise, it doesn't comply with the rule. But the new rule goes even further for reasons that, frankly, I never understood. But the new rule says the agreement has to be obtained at the time the agreement is made to pay a referral fee, or as soon as reasonable thereafter. Meaning you have to do it at the beginning of the relationship when you make the agreement to pay a fee. To me, the reason I say it doesn't make sense is oftentimes, particularly if lawyers are actually both working on the case, it's impossible to predict how much effort one as opposed to the other may end up putting in. If one lawyer has it pre-lit, they may do the lion's share of the work, and the lawyer who takes it into litigation may settle the case immediately thereafter, or vice versa. And a lot of times you don't know what the fee split should be, what you'll agree to, what will be fair and reasonable until after all that work is done. Doesn't change the fact that the rule says now you must get the agreement at the beginning of that arrangement, and you must have the client's consent. What happens?
Can you say we don't know yet what it's going to be, and we'll inform you as soon as we know?
Again, the rule is relatively new. There's literally no cases that I'm aware of, certainly no reported cases which have made any interpretation of the statute. On its face, the rule says no. It says you have to do it when the arrangement is made or within a reasonable period thereafter. The term reasonable is not defined. So I suppose you could make the argument that it's not reasonable to come to that conclusion until you know what their respective contribution of the lawyers will be. Let me just say one other thing. The case law has developed that, so the California Supreme Court in a case called Chambers versus Kay interpreted the predecessor version of this rule to mean that because the rules of professional conduct are there to protect the public, it would be violative of public policy for the court to enforce an agreement that does not comply with the rule of professional conduct. So in that case, even though it was pretty clear that there had been an actual agreement between the lawyers, and in fact, the plaintiff lawyer had done work on that case when it was being litigated, the Supreme Court said, we are not going to enforce your agreement. It's against public policy. You didn't comply with the rule. You're out. It's unenforceable. But subsequent appellate cases have said, but you still are entitled to quantum merit. It doesn't mean you get nothing, but you're going to have to prove now what was the value of the work that you did for the case, because you can't enforce the agreement. David, do you see in the malpractice side, are you seeing many cases that implicate the lack of compliance with the referral fee rule?
It's something that does come up. I mean, lack of compliance with rules is, fertile ground for plaintiffs' counsel. It's the sort of thing that they love to throw into complaints anytime you can. The rules themselves say they're not meant to establish an independent basis for liability, but on the other hand, there is case law saying the rules of professional conduct help to define a lawyer's fiduciary duty to a client. So, anytime there is non-compliance with the rule, it creates a hook for a potential claim. It creates something to be litigated over. And in particular, violation of rules to void or attempt to void agreements is something that we see a lot, particularly after Shepard-Mullen versus JM Manufacturing. I think that's led to a large expansion in attempts to avoid agreements by clients, particularly because, certain rules are broadly worded. You have a duty to be diligent or to be competent. And creative attorneys might say, well, if you violated this rule and the violation of a rule of professional conduct means an agreement's not enforceable, a lot of times we see creative arguments that I think go beyond what the Supreme Court was dealing with in Shepard-Mullen, which was a conflict of interest issue, where you would see, the voidable nature of that agreement a little more clearly, to try to expand that argument into other rules that may be more broadly worded, and violations may be a little trickier, and usually the sort of things you need expert testimony on, frankly.
Ellen, could you just tell us what the temperature is at the State Bar in light of Girardi and any other more recent developments?
Well, that's a large topic. So very briefly, there's a lot going on at the State Bar with respect to studying the discipline system, and not just only relating to the Girardi situation. For example, the State Bar of California itself issued a report in the summer of 2020, which revealed that there's a great disparity in levels of discipline that are imposed. African-American male lawyers are disciplined at a much higher rate than other lawyers. And in fact, African-American male lawyers are disbarred at a rate of 4 to 1 of white male lawyers. So the State Bar is looking at, whether the discipline system itself is fair. There is an ad hoc commission on discipline that has been appointed. I'm a member of that commission. We, in the defense bar, are trying to get the State Bar to look at lots and lots of issues. We see lots of problems. Anecdotally, we're trying to get data to explore why, for example, the State Bar pursues cases that end up getting dismissed. Are they getting the lesson that the court is sending them about some of the matters that they're pursuing, when it seems that, clear to those of us who are doing defense that those cases are never going to succeed. And with respect to the trust account issue, to me, the irony is, so let me digress for a moment and say, I started at the state bar as a prosecutor in 1978. I've been doing state bar defense since 1989. I've represented many thousands of lawyers. It's not that uncommon for a lawyer to have a trust account problem because, among other things, we're not trained. There's no training in client trust accounting. A lawyer can become admitted to the bar, open up their own shop, and then everybody's flying by the seat of their pants. They don't know accounting. And as I say, it's not mandatory that they receive training in proper client trust accounting procedures. So the percentage of lawyers who may have some problem, a check bounces. Why would the check bounce? Well, maybe the deposit bounced. Maybe your client wrote you a bad check and you didn't wait long enough, or the bank clawed it back 2 weeks later when it showed up as being clear on your account. Whatever the reason, you could have the state bar looking at a trust account problem. The percentage of lawyers who steal clients' money is minuscule, and it's such a tiny percentage. If you even look at the discipline report, which you can read, in the Daily Journal or the Recorder or whatever, the number of lawyers who are stealing client money is probably 1%. Certainly less than 5%. So what's the state bar response to the allegation that clients of this very prominent, successful, well-known lawyer had not received their settlement funds for many months or even longer, and the state bar failed to investigate? The state bar failed to use its subpoena power, which it has. And in fact, if the state bar has unilaterally determined that there's a problem with the lawyer's trust account, they have the right, and they do subpoena the trust account without prior notice to the lawyer. The lawyer only learns about it after the fact, after the state bar has a record. They've always had that power. They had the power, at all times during the last 50 years. So, the state bar's response is, oh, well, we need to have more money, and the legislature needs to authorize us, and they've adopted a program to do more random audits of trust accounts. Well, a random audit that doesn't happen to pick up the 1% or 5% of lawyers who are misusing their trust account isn't going to help. They're not going to audit every single lawyer. So, the state bar is always, I would say, concerned, because they feel that the public doesn't like lawyers. They feel that the legislature always thinks the state bar is being too lenient on lawyers. And even though the state bar has an annual budget of $60 million to discipline lawyers, the bottom line is there's usually about 600 lawyers a year that get disciplined. Not because the state bar is not doing its job, but because the vast majority of lawyers are not committing ethical violations. So in a nutshell, that's what's going on now. And we'll see. We'll see if the legislature wants to give the bar more money so they can hire more people. It remains to be seen.
Thank you, Ellen. And now Mr. Samani, who leads one of the major practice groups for lawyer defense.
Thanks, Neville. I wanted to, so with respect to malpractice and avoidance of malpractice and risk management, I want to go back to a key point that Ellen raised and Neville both. With respect to retainer agreements and fee agreements, Ellen mentioned earlier setting forth scope of representation. That's something that can be invaluable to helping from a risk management perspective. A written agreement which delineates the work that's going to be performed. It can be useful in two respects, primarily in the defense of or avoidance of legal malpractice claims. The first thing it helps to do is establish what the scope of the duty is on the part of an attorney. It's very easy, if there is no written agreement that contains an express delineation of what services the lawyer is going to provide to the client, for a client to expand a lawyer's obligations when it comes to a subsequent lawsuit. Lawyers can be hit with claims that they had no clue that that they didn't envision ever providing services on. Now, in some respects, there are general duties that can attach in a representation. If something is anticipated or related to what you're retained for, even if it's not expressly delineated, it might be part of the lawyer's duty to at least flag it for a client, advise that there may need to be separate counsel to investigate an issue. The other thing that written retainer agreements are very helpful for when it comes to defense or avoidance of malpractice is with respect to our statute of limitations. Lawyers have a special statute of limitations, Code of Civil Procedures, section 340.6, which can be a very powerful defense tool. And one of the statute has two components. There's a 4-year occurrence-based statute, but also a 1-year statute that runs on discovery of a claim. But it has 2 tolling provisions. Well, it actually has more than 2 tolling provisions. It has 5 tolling provisions that are enumerated, but 2 that we typically see come up when defending lawyers, one of which is lack of actual injury, the second of which is continuous representation. And continuous representation will toll the statute for so long as a lawyer continues to represent the client on the same specific subject matter. Where fee agreements can become very helpful is it has to be the same specific subject matter. So you can be representing a client, on one litigation, and separate and completely unrelated client might come in and say, I want you to prepare a will for me or handle a transaction. Now, the separate, whatever the claim for malpractice relates to, you should the fact that there's another representation should not toll the statute. Written agreements can help by delineating scope of representation, can help establish that they are separate, and the fact that further work is being done for a client does not necessarily toll a statute. And if you don't have a written agreement, you can sometimes create issues, or there can be a possibility for that situation to become muddy in subsequent litigation. Another thing that's really kind of useful in that respect, and this goes to something that Neville mentioned before about papering, when representation is over, some sort of letter, correspondence, email, anything just indicating we've completed the tasks you engaged us for on this matter, this will conclude our representation, anything like that can be very helpful from a risk management perspective, because it's going to cut off, or at least will help create the argument that any tolling for continuous representation should end if you have something like that, something that sets forth a kind of clear demarcation that the representation has concluded. Now, sticking with Ellen's theme of monetary matters, I wanted to discuss some of the recent case law that came out last year in the malpractice field dealing with causation of damages, which are important issues in malpractice cases in an area where the courts of appeal in particular focused on when it comes to defending against those claims and the burden a client has to face. One such case that came out last year, which did involve an underlying entertainment matter, was Michaels versus Greenberg-Traurig. And that case involved the plaintiff was Jillian Michaels, who had engaged the attorney defendants to assist her with 2 sets of contracts that were at issue. One of which was her agreement to appear on the TV show The Biggest Loser. And another was an agreement she had with a nutraceutical company for branding and promotional work. And the issue that arose in that case was there was 2 conflicting provisions between the contracts. The Biggest Loser agreement essentially restricted Ms. Michaels' ability to appear on commercials, and that restriction conflicted with warranty provisions that were in the branding agreement with the nutraceutical company. And, so as is often the case with claims against lawyers, things go awry. Ms. Michaels' relationship with the nutraceutical company degenerates a bit, and they end up in litigation where the nutraceutical company advances a claim of fraud based on the fact that she had represented and warranted that she was free to market, and that was not true because of the Biggest Loser agreement. So when that case resolves, Ms. Michaels turns to the lawyers and sues them for malpractice. And that case originally ended up in the Court of Appeal after granting of a motion for summary adjudication and essentially summary judgment. And on the ground of Ms. Michaels could not establish causation. And the case provided kind of a helpful refresher on what causation means against a lawyer. Typically, the test is usually stated as that the client has to demonstrate, but for the attorney's alleged error, she would have had a better result. That's the test that applies irrespective of whether you're talking about a transactional malpractice or litigation malpractice case. And what the Michaels case, reaffirmed, that's the test. In transactional cases, you typically see it play out in that the client has to demonstrate that but for this alleged error, the client would have either negotiated a better deal, or if the client did not engage in any deal, the no deal scenario, the client would have had a better result. And what was somewhat concerning for people like me who defend lawyers, in the Michaels case, the court reversed the granting of the summary judgment and concluded that a triable issue of fact had been shown. In doing so, based primarily on Michaels' submission of an expert witness declaration demonstrating what her supposed lost profits would have been, concluded that she had shown at least a triable issue of fact that no deal, her having walked away from one of the two agreements, would have led to a better result. And this opinion is concerning to defense lawyers like me because the Court of Appeal relaxed a bit or concluded that the trial court was too strict in acting as a gatekeeper and reviewing that expert declaration, and that the evidence should have been construed more favorably to the plaintiff. And it highlights some of the risks facing lawyers because causation is usually a very powerful tool, but to the extent there's a relaxation in the type of evidence that's necessary to demonstrate a triable issue of fact, that's something that creates the risk of more trials, more litigation, and keeps me in work, but is not great for everyone when it comes to insurance premiums and things of that nature. So Michaels is the latest on causation in the transactional context. In the litigation context, some of you may have heard the phrase case within a case before. You have the typical same type of causation standard, but for the alleged error, would the client have obtained a better result? And normally that has been construed kind of consistently to mean that a client has to show that but for the alleged malpractice, they would have prevailed in the underlying litigation. And actually we had two cases last year come out, O'Shea versus Lindenberg and the Letgolds case versus David H. Pearson Associates, both of which are in the materials, the year in review article, I believe, has been provided, both of which reaffirmed that principle of, but for the alleged error, would the client have prevailed? What's interesting, since that, and again, that test has kind of been, the Supreme Court likes to say it's been around for 120 years to safeguard lawyers against speculative claims. You see that in some case law occasionally. It's been refined a bit over the years, particularly in what we call settle and sue cases, where there have been the recognition that it may not require a client to show they would have won if they can show they would have gotten a better settlement, to a reason, to the standards required. There are certain certainty requirements that are necessary that I could talk about at length at another time, but keeping with an overview. So those two cases reconfirmed the case within a case type analysis. What's interesting is there's another type of theory that has kind of flown under the radar as far as the Court of Appeal is concerned, but which we may actually see soon. We're monitoring a case now where this is at issue. And that is where the client sort of flips the claim and says, no, I wouldn't have prevailed in the underlying case. I should have never had to file the case. The lawyer should have told me that my case lacked merit, and just by filing it, I incurred fees, costs, what have you. I should have been told to take my ball and go home. I like to call them the guardian angel cases. It's not one that you've seen a lot of appellate authority on, But now currently in the Court of Appeal, there is a case pending where the claim is it was an underlying defamation claim. It was subjected to an anti-SLAPP motion, which was granted. And as a result of the granting of the anti-SLAPP motion, the client was assessed a fee award against him. And so he has now sued the lawyers saying, I should have been warned about the risk of this fee award in the anti-SLAPP statute. And had I known about that, I never would have filed my case. So it's one to watch because it's not quite clear what happens to our causation standard when that's the theory. The case within a case doesn't apply. It's sort of like a no deal type scenario in Michael's. If the plaintiff can say, well, filing no case at all would have been a better result for me. I should have filed no case. And that might be what the Court of Appeal ends up holding here. But what we haven't had is any sort of guidance as to how it works as a practical matter in litigation. Because one thing it seems to me is that that type of theory almost negates causation as a practical matter. If a breach is shown, then causation, the damages seem to flow directly from the breach, even a filing fee. If you should have never filed the lawsuit, even the cost of filing the lawsuit could be damage. So it's an interesting one to watch, whether we're going to get guidance on that or not. And it goes to, again, a theme that Neville and Ellen both commented on, papering the file. A lot of these types of claims can be, you can manage this risk by proactively papering the file about what are the risks of litigation, things like the anti-SLAPP statute, things like prevailing party attorney's fees clauses that could come, up. If you lose, you might end up owing this money. A lot of legal malpractice cases can be avoided if there is something written in the file. If it's not written and it's not in the file, even if you told someone, that's a triable issue of fact. And so you're just going to have to assume that that's going to end up in trial, to a jury. So getting it in writing absolutely, remains kind of a critical thing. Another issue, briefly, that we did see a kind of uptick in when it comes to Court of Appeal cases were sanctions and civility issues. There were quite a few decisions over the last couple of years where the Court of Appeal basically bemoaned the lack of civility in connection with assessing monetary sanctions, whether it be for frivolous appeal or contemptible conduct. One such case, this is again in the materials that were provided, is Malik Media Group versus AXQG Corporation. That involved a $56,000 sanction imposed for filing a frivolous appeal in an attempt to overturn or vacate an arbitration award. What you had in that case was the plaintiff essentially arguing that the arbitrator had failed to disclose his connections to GLAD, and that those connections to GLAD rendered him partial because the plaintiff was a Catholic white male, and GLAD's position on the Me Too movement and things like that necessarily meant the arbitrator could not be impartial to the plaintiff because he was a Catholic white male and therefore would have had the benefit of white male privilege. And as you can imagine, the Court of Appeal did not look kindly on this argument and concluded, objectively and subjectively frivolous for that argument to be made. Hence, the sanction order, both against client and attorney, and of course, the order being referred to the state bar in light of the sanctions being assessed against the attorney. So, things like that demonstrate, again, kind of the risks of, that lawyer has plenty of problems as it is, having filed that brief, but I also hope that he warned the client ahead of time about the arguments that the client wanted them to make. I presume the client was the motivating factor behind the submission of such paperwork, and that's the sort of thing that you would hope that he papered his file. Can
I jump in for a second,
Sure,
David?
yeah.
I just want to make sure that everybody's aware. Under the B&P code, section 60680, there are certain kinds of sanctions that a lawyer is required to self-report to the bar. So if the lawyer is sanctioned at the amount of $1,000 or more, except if it's discovery sanctions, that is self-reportable. And it's also a separate disciplinary offense if the lawyer fails to self-report to the state bar. So sometimes you'll see lawyers who don't get disciplined because of the conduct that gave rise to the sanctions, but they may end up with some sort of disciplinary disposition for their failure to have reported it. So if you have the misfortune of having been sanctioned, please make sure that you check that out.
That's right, absolutely. And there are a few other cases in the materials that are of interest when it comes to this issue of civility. Carton versus Area Design and Construction, Inc. involved a court of appeal reducing a fee award to a prevailing party, essentially based on the prevailing attorney, his incivility in the litigation. Court saying that, a reduction can be justified for that type of conduct. And again, that could be the sort of thing that a client may not look kindly on when they find out that their position has been adversely affected. If the attorney's going to then say, well, I need to be made whole. I didn't get all the fees that I earned for you. And well, why is that? Because I was in civil. That's not a sort of situation you want to be in, where you talk to your client and tell them that. Very often malpractice claims are tied to fees. It's not uncommon to see reactive malpractice claims when there's money owed and a client doesn't want to pay them. So all things to keep in mind. We have some time left. I don't know if we should transition to questions. I do think we have a few if we want to deal with those.
Okay, here's, I'll take one, and then I've got something for David. Could we clarify my comment on arbitration clauses? I recommend arbitration clauses. I'm just saying there's a theory out there that's never been tested, but from employment cases that had mandatory arbitration, the employer was required to pay. That was a rule that basically came down, and will that be applied in a fee dispute? Who knows? I don't know.
Let me jump in, Neville. There is case law in the attorney-client context that says sometimes, hey, if your client cannot pay for binding arbitration, they can make a showing that because of poverty or what have you, they lack the resources. Attorney, you can arbitrate, but you might have to pay the costs. So, that could be an issue that does come up. And just generally to address arbitration clauses, it's a lot of clients like to have them because it's a more private forum and you can stay out of public record. I will say that a lot of insurance carriers don't like them when it comes to the defense of malpractice claims. They don't like waiving an appeal. They don't like arbitrators are usually less likely to grant dispositive motions. You could be limited in discovery. So carriers generally don't like them. Of course, if you have one in your retainer agreement, you can always then have a discussion with your carrier about, this is one we want to arbitrate or not. So, it's always a decision to make whether that's something you want to put in there.
What do you recommend?
Generally, it depends on the case. I like to talk about my clients, but where we think something is very technical or maybe really driven by fees, and it's going to involve fees more than, a kind of a clean causation argument where we think we have a great MSJ, those I like to keep in arbitration. If I think it's a case where there's a strong legal defense, we tend to want to be in court, have our right to appeal, have our MSJ.
Right. So let me understand, you're saying there is authority that a lawyer would have to pay if the client can't?
There is some authority that says that if the client lacks the ability to pay for an arbitration, that if the attorney defendant wishes to proceed with arbitration, the attorney defendant will have to pay.
Is the antidote for that to say the lawyer at his option can require it to proceed then in the civil court system or choose to pay?
So in that case, that was essentially the holding was this. If you want to go to arbitration, that's fine, but you're going to have to pay for it, lawyer. Otherwise, stay in the court system.
The lawyer won't be bound to have to go to arbitration if the client is penurious.
Right, I have not seen any authority that would suggest that.
All right, for you,
There's
David.
one more, before you move on, there's one more thing I want to mention, and that is, there is case law from the Supreme Court, I think it's Aguilar versus Lerner, that says that a contractual arbitration clause does not supersede the Mandatory Fee Arbitration Act, which is B&P Code 6200. So the way it works is, even if you have an arbitration, a binding arbitration provision in your fee agreement, the client is going to be able to compel the lawyer first to arbitration under the MFAA. If the parties do not agree that the fee arbitration is, that the statutory fee arbitration is binding, then the result will not be binding. And after that result, if the lawyer doesn't like it, then the lawyer can compel that client to the binding arbitration under the fee agreement. So it's a little complicated, but don't assume that if you have a fee arbitration clause that you're going to be able to avoid the MFAA procedure. You will not be able to.
Okay, we have one participant saying, what's the purpose of the table of contents you provided, and the cases you talked about are not in the materials? Do you mean that they were in the newspaper articles that you had?
Yeah, I apologize. I know Ken Feldman had sent that. I don't know if that didn't make it in. If we weren't able to get those, I can type the cases out in the chat here that I mentioned. Since I was referring to the year in review articles that were published in the Daily Journal, but
We have those articles. We have those articles.
maybe they didn't make it into the materials.
I think they may be separate attachments, not in the outline, but in the other documents that that are linked.
This is a question from one of our viewers. Are arbitration agreements binding when signed ahead of the time contained in the representation agreement, or does the client need to agree to arbitration after the dispute arises? If you can understand that.
So there is no requirement that it has to be after a dispute arises. Typically, we see them in fee agreements, is where you have your arbitration clause. They are generally binding, but they're subject to the same defenses that would apply to any contractual arbitration provision. So, we see people complain that it's unconscionable, and so it's always helpful to bold it. Make it really large and have the client initial it separately or something, so it's clear that they reviewed it and that there's no substantive or procedural unconscionability. But there is no requirement that it be agreed to after the dispute has arisen. I mean, you can stipulate to arbitration after dispute has arisen, but you can also go ahead, Ellen. Sorry.
I just want to, I know we're running out of time. It's very important, if you're going to do a binding fee arbitration, to include in there a disclosure to the client that they're giving up their constitutional right to a jury trial. I was an expert witness in a case in which that was the issue. And there's actually case law on it saying that that's not a requirement because arbitration is favored. And, the courts tend to enforce arbitration clauses, but you'll still have clients raise that as a defense. So if you're going to do it, make sure you include that. And not to contradict anything that David said, but keep in mind that under the MFAA, if a dispute arises, the lawyer has a statutory duty to give the client notice of right to arbitrate. So even if you have an arbitration agreement or provision in your fee agreement, under the statute, when the dispute arises, especially if you don't want to go to arbitration, you want to give the client that notice, because if they don't institute, they meaning the client, if the client does not institute fee arbitration within 30 days of receiving that notice, they waive their right to compel you to arbitration.
And I mentioned, I've had a couple of instances where I've had those non-binding arbitrations. In one case, the case settled. And in the other case, the three people hearing it, none of them were lawyers, which I thought was interesting as well. So, but it may have value, and that case settled afterwards as well, because they see that the client is serious about what they're doing. Okay, well, listen, we are at the hour that we have done. As it went quickly. I'm really honored to be with these two panelists, and we really appreciate it. Thank you very much.
Thank you.
Thanks, everyone.